Hello, everyone, and thank you for tuning in to the Constitutional Accountability Center's 10th annual Home Stretch at the Supreme Court event. I'm Elizabeth Wydra, the Constitutional Accountability Center's president, and I am so thrilled that you could join us today and be part of the conversation that we'll be having in a moment with a spectacular group of panelists. So, as I just mentioned, this is our 10th time putting on this home stretch event that we host every year after the close of oral arguments for the term. And this 10-year marker is a useful one as we reflect on where we are with this court and compare and contrast. So 10 years ago in 2013, CAC was not quite in its infancy, maybe in its toddlerhood, and folks were warming up to our text and history methodology, often called progressive originalism, after a bit of initial skepticism from some corners, and finally welcoming the rejoinder to conservative originalists on the court and off the court. Now, of course, 10 years later, with Justices Kennedy and Ginsburg off the court and a supermajority of very conservative justices, CAC's text and history arguments may very well be, as Dahlia Lithwick put it to me when I was on her podcast last year, progressives' last best hope of securing victories in the court. And just a fun fact, Dahlia was the moderator of our very first homestretch event at the National Press Club. Again, looking back 10 years ago in 2013, we were awaiting the court's affirmative action ruling in Fisher versus Texas, the first time it was at the court, and ultimately breathing a sigh of relief when the court remanded the case back to the Fifth Circuit, while seeming to take as given the Grutter precedent, which allowed educational institutions to take race into account under certain circumstances in order to create opportunity and the better educational experience that having a diverse student body brings for everyone. Now, 10 years later, we have a duo of cases that present this conservative court with the opportunity to reverse those affirmative action precedents and forbid the use of meaningful race-conscious admissions policies. Again, 10 years ago in 2013, we were looking forward to the court's decision in the Windsor case, in which the court would rule that Section 3 of the so-called Defense of Marriage Act was unconstitutional and that the federal government could not discriminate against married LGBTQ couples for the purposes of determining federal benefits and protections. Now, 10 years later, in 2023, we await a ruling in 303 Creative versus Alanis, in which claims of religious free exercise could be used to pick away at the constitutional protection for marriage equality, providing a license to discriminate against LGBTQ couples. 10 years ago, the Supreme Court gutted the Voting Rights Act in Shelby County versus Holder, with scant constitutional reasoning and plenty of incorrect suppositions about the state of democracy in this country. Now, 10 years later, well, some things haven't changed that much on that score. And finally, 10 years ago, the Supreme Court enjoyed a relatively high favorability rate, with a strong majority of Americans having trust in the court. Now, 10 years later, that trust has plunged, and a majority of Americans do not have trust in the judiciary. It is deeply unfortunate, but not difficult to see why the court finds itself in this crisis of legitimacy. The justices' refusal to accept the binding code of ethics that governs all other federal judges has eroded faith that they are acting as impartial jurists. And the string of questionable ethical situations that have been reported on in the press have only added to this loss of faith. A fair judiciary requires both the appearance and reality of impartiality. But perhaps even more than that is the string of substantive rulings that make Americans question whether this is a court that follows the text and history of the law where it leads, instead of following an ideological or partisan agenda. You don't need to be a constitutional scholar or an appellate lawyer to know that a vision of equality and liberty that does not include the right to make fundamental decisions about whether, with whom, and when to have a family is a hollow vision of constitutional equality and liberty indeed. You don't need to be a constitutional scholar or an appellate lawyer to know that an articulation of freedom that does not include the freedom of bodily autonomy, including the right to choose for oneself whether to terminate a pregnancy, cannot be genuine freedom as articulated in our national charter. The free fall of faith in the court, to me, reflects that the American people get that some sort of irreducible minimum of liberty must be protected by the Constitution if equality and liberty are to have any meaning. And the court's overturning of Roe caused massive questioning of the court's commitment to those principles. So fortunately, we have an all-star panel today to help us unpack all of this and more. I'm extremely grateful that we are joined today by Easha Anand, co-director of the Stanford Law School Supreme Court Litigation Clinic and Supreme Court and Appellate Counsel at the MacArthur Justice Center; Tona Boyd, Associate Director-Counsel of the NAACP Legal Defense and Education Fund; David Cole, Legal Director of the American Civil Liberties Union; and our own Brianne Gorod, Constitutional Accountability Center's Chief Counsel and my brilliant colleague. Our conversation will be moderated by the always fabulous Joan Biskupic, CNN Senior Supreme Court Analyst and author of the recently released and much acclaimed book, 9 Black Robes. I highly suggest you check it out. And Joan, we're so lucky to have you lead us through this conversation today.
Thanks, Elizabeth. And, I'd forgotten about the event at the National Press Club 10 years ago. I was there and I remember Dahlia's remarks. So it's good to be brought back to that moment. And it's also good to be reminded of how much has happened since then. I'm pleased to be here with our panelists who indeed really make up an all-star group to give us some insights on this session, which is named the home stretch. But frankly, the race hasn't even started. We haven't gotten many rulings yet. And there's just so much looming. Will we have a term like last year's? Will we see more divisions on the right? What more will we figure out about our newest justices, Amy Coney Barrett and Ketanji Brown Jackson? There are just so many questions that we have so little evidence of yet. And I think that we've got exactly the right 4 panelists to try to shed light on the developments at the courts and things that we should all be watching for in June. Now, CAC has divided up the top 10 cases into 3 distinct topics, and I just want to let our audience know how we're going to proceed. The first will be the Constitution and the myth of race blindness, then the Constitution and state governmental action, and the Constitution and economic justice. As I said, we'll have about 10 cases to cover in this about 40-minute portion, and then we will have audience questions come in. So please be submitting those as we go along. But I do want to say that we're covering a lot of ground in a short period of time. So our panelists will probably not go heavy on the facts, which most of you already know the facts of these cases, how they got up to the court, and instead use their own expertise to point up the stakes and what patterns we've discerned so far during oral arguments. So first up right away to Tona on our 2 really major racial disputes. Students for Fair Admissions versus Harvard and Students for Fair Admissions versus the University of North Carolina. These are cases that pose a direct challenge to the 2003 Gorod versus Bollinger case and the 1978 Bakke. And then Tona will segue into the topic of race with Merrill versus Milligan. And I'm so glad to have been reminded by Elizabeth that we all thought we knew where the Fisher case was originally going to go, Fisher Part 1. And, we realized that in the end, affirmative action prevailed in those University of Texas at Austin cases. And Tona, as you start your session, if you would just let us know if you think there is any way in this case in 2023, we will not see major rulings against Harvard and UNC. And then when you take on the Voting Rights Act, just what you think would be the consequences of further cutting back on Section 2. Tona.
Thank you so much, Joan. So our nation is really in the midst of an ongoing and significant attack on decades of work to build a multiracial, multi-ethnic democracy that centers racial equality. And we've seen these pernicious attacks manifest in the assault on truth that's taking place around the country, where states are passing laws designed to erase the rich tapestry of diversity and the lived experiences of Black communities, other communities of color, and LGBTQ communities. And that erasure is taking place from our books, our libraries, our classrooms, our universities, and even most recently, we've seen those attempts to eliminate diverse voices from the legislatures in Tennessee and now most recently in Montana. And these efforts have also shown up in litigation that has been designed to overrule race-conscious admissions in higher education and from vote dilution claims in the context of redistricting in the application of Section 2 of the Voting Rights Act. So I'll start off with the affirmative action cases. As Joan flagged, the first set of cases are Students for Fair Admissions versus Harvard and Students for Fair Admissions versus the University of North Carolina, and they challenge those schools' race-conscious admissions policies. And the key question there, of course, as Joan flagged, is whether the Supreme Court should overrule Gorod v. Bollinger and hold that institutions of higher education cannot use race as one of many factors in considering college admissions applications. So Students for Fair Admission argue that the Equal Protection Clause in the UNC case and Title VI of the Civil Rights Act in the Harvard case bar affirmative action altogether. And in the Harvard case, they claim that Harvard's race-conscious admissions policies discriminated against Asian American applicants. Now, we know both the district court and the First Circuit ruled in favor of Harvard, finding no evidence of animus towards Asian Americans and no evidence that any particular admissions decision was negatively affected by Asian American identity. In the Harvard case, LDF represented 25 student and alumni organizations comprised of thousands of Asian American, Black, Latinx, Native American, and white Harvard students and alumni as amici curiae. And we also filed an amicus in support of UNC in the case. And the thrust of our argument is that banning race-conscious admissions reinforces inequalities and opportunity based on race and background. As we highlight in our brief, no racial group has a monopoly on talent, but some students enjoy a monopoly on opportunity. Due to persistent racial inequalities in our pre-K through 12 educational systems, most students of color and Black students in particular confront barriers to educational opportunities despite their qualifications and hard work. And those barriers exist across economic strata. Now, notably in these cases, Students for Fair Admissions audaciously argue that Brown versus Board of Education stands for the principle of colorblindness, which really turns that seminal decision on its head. And the import of that would be to transform Brown from being the indictment against racial apartheid in this country that it is, into instead a tool that would deepen persistent inequalities in educational opportunities. Now, Joan, to your question at the top, I think we should not presume that the court will outlaw race-conscious admissions. I think many predicted the downfall of race-conscious admissions previously, as you noted, when the University of Michigan cases were before the Supreme Court, and again, when the Fisher case was pending, and the court surprised many when it ruled again and again that it remained legally permissible for colleges and universities to consider race as one of many factors in admissions. So any ruling that really would call into question the legality of race-conscious admissions would be a sweeping reversal of more than 40 years of Supreme Court decisions that have consistently confirmed the constitutionality and legality of race-conscious admissions in higher education. And I think the impact of eliminating race-conscious admissions cannot really be overstated. I mean, eliminating the consideration of race could cause the number of Black, Latinx, Native American, Hawaiian, and Pacific Islander students to plummet by 50% at some schools, which would exacerbate racial isolation and deny all students of the benefits of a diverse student body. And remember, when California passed Proposition 209, which banned the consideration of race in the University of California system in 1996, the number of Black students admitted to the freshman class at UC Berkeley under that new policy dropped by 66%. So I don't think that the impact can really be overstated. The second case I'm going to turn to now, confronting the court with respect to race-conscious measures, is in the voting rights context, and that's Merrill versus Milligan. This is a case about racial gerrymandering, and LDF's own Duell Ross argued the case before the Supreme Court last October. The case centers around, as we know, the congressional maps for the state of Alabama. So while Black people make up about 27% of Alabama's population, the state created a congressional map where only one of its 7 congressional districts is majority Black. So in that case, LDF represents a group of registered voters, the Alabama NAACP, and a multi-faith community organization. And we sued Alabama, arguing that the state illegally packed Black voters into a single district in violation of Section 2 of the Voting Rights Act, which prohibits racial discrimination in election practices. Now, a 3-judge panel agreed with us and ordered Alabama to create a map with 2 majority Black districts. Alabama sought an emergency stay in the Supreme Court, which the court granted, and that enabled Alabama to proceed with its map with 1 majority Black district, which remained in place for the 2022 elections. Now, in the case, Alabama argues that interpreting Section 2 to require the creation of a second majority Black district violates the Constitution because it would require race-based sorting. Now, Justice Jackson, importantly during oral arguments, reminded the court, quote, "I don't think that the historical record establishes that the founders believed that race neutrality or race blindness was required, and that the 14th Amendment was drafted to give a constitutional foundation for a piece of legislation that was designed to make people who had less rights and less opportunity equal to white citizens." You know, she fairly starkly stated that this was not a race neutral or a race blind idea. So should the court accept Alabama's argument that race should play no role whatsoever in redistricting plans under the Voting Rights Act, it would dramatically limit the scope of Section 2 and reshape litigants' ability to bring vote dilution claims. I think it's important to note here Alabama's history. Alabama has a history of racial terror and exclusion when it comes to the struggle for voting rights for Black people. It was far from race neutral or colorblind. Every year, LDF commemorates Bloody Sunday, which is the historic day in which the Honorable John Lewis and other civil rights foot soldiers marched across the Edmund Pettus Bridge in Selma, Alabama, to demand that Blacks be afforded the right to vote. And in many ways, that march was the birth of modern American democracy, because the Voting Rights Act, arguably one of the most consequential pieces of civil rights legislation ever, was passed. But we know that that bill has gradually been chipped away at and significantly weakened by the court, most notably in the Shelby case, which gutted Section 5 of the Voting Rights Act. So the court's decision in Milligan will either allow Black voters to have a fair shot at electing candidates of their choice, or permit states to ignore the legacy of racial discrimination and the very purpose of the Voting Rights Act, which was to dismantle and remedy the enduring roadblocks to full Black citizenship and civic participation. So I think the question presented by these cases is, will the court entertain the fallacy of a colorblind constitution in the face of not only a history built on systemic and state-sponsored racism, but in the face of all of the evidence of the ways in which that legacy persists and stains our democracy today? Or will the court live up to the call to do equal justice under law, as is etched in its facade?
Thanks, Tona. And I want to remind the audience that you can start even putting some questions into the queue so that we have those ready when the time comes. Thanks again, Tona. For our next section on the Constitution and state governmental action, David and Brianne will both have cases, Moore versus Harper, then Brianne will do the pork industry one, and then David will follow up again with 303 Creative versus Elenis. But first, David, if you would do Moore versus Harper, a case that some of us thought maybe we wouldn't be doing right now because some of the parties have asked that it have advised the court that it should be dismissed. So as you take this one on, you might want to comment on whether you think that they're actually going to decide it now that they haven't gotten rid of it.
Right. So thanks, Joan. So I think you can see Moore versus Harper and 303 Creative, which I'll talk about a bit later, as of a piece with the two cases that Tona just spoke about. They're all cases in which litigants are advancing the Constitution as efforts to get the court to block efforts by other entities to further equality. So in the affirmative action, it's to block schools from seeking to further equality. In the Voting Rights Act, it's to block Congress from seeking to further equality in voting representation. And in Moore versus Harper, it's an effort to invoke the Constitution to block state courts from holding their legislatures accountable by barring them from engaging in partisan gerrymandering and ensuring that everyone has a right to a free and fair election. So the case comes out of North Carolina, where the North Carolina Republican majority legislature engaged in a pretty dramatic partisan gerrymander of their maps after the 2020 census, and the North Carolina Supreme Court declared that partisan gerrymandering violated the constitutional right to free and fair elections in North Carolina and sent it back. And the North Carolina Republican legislatures took that to the U.S. Supreme Court, arguing that a provision in the Constitution that gives the legislature of each state the power to set the time, place, and manner of elections for Congress precludes state courts from holding state legislatures to their own state constitutions. I think there's still a possibility that the court will not decide the case because the North Carolina Supreme Court, which has changed in its political makeup since this case was first taken up by the court, has agreed to reconsider part of that earlier decision. And so some of the advocates are arguing that the case is not final, the dispute is not final, and the court should therefore the Supreme Court should not take it up as long as the North Carolina court is still dealing with it. Others have urged the court to decide the case. In one way or another, the court's going to have to decide this issue. And I think what the argument illustrated, if you can, go by the argument, is that there's really very little appetite for the really extreme argument that the framers of the Constitution somehow meant to set state legislatures above the law and allow them to engage in conduct that violates their own constitutions. I think there's support on the court that no, state legislatures are products of their own state constitutions, and they have to act consistent with their state constitutions. And it's was fully contemplated that state courts would hold state legislatures accountable to their own state constitutions. I think there is likely to be a consensus, probably across party lines, that at some point, a state court may overreach and override the legislature's authority, namely where it's no longer acting as a court, where it sort of makes it up out of whole cloth and imposes some result on the legislature. But I don't think that's this case. And so, this is a case where I think we were all very worried about. I'm less worried about after oral argument than I was beforehand, because I think, as I said, very few justices seem to have appetite for the extreme view.
Thanks, David. And we'll get back to you in a minute on 303 creative. But Brianne, in the meantime, is going to pick up National Pork Producers Council versus Ross. And this was one of the early cases from the October sitting. So, I'd be interested in your thoughts about what the real sticking points are for this case too, Brianne.
Sure. Well, this is a case that, given all the blockbusters at the court this year, has received relatively little attention, but it's actually incredibly important, particularly when it comes to thinking about the court and state governmental action. This is a case, as Joan said, that involves a challenge to California's Proposition 12, which banned the sale in California of pork meat that was produced using extreme methods of animal confinement. Industry groups filed a lawsuit to overturn Proposition 12, arguing that it's unconstitutional under the Dormant Commerce Clause. This is a doctrine that limits states' ability to pass laws that affect interstate commerce. Now, there's a lot that is wrong with this argument, both as a matter of Supreme Court precedent and constitutional history. And I want to focus for a moment on that constitutional history, because when you understand why the framers adopted the Commerce Clause, it's clear why there's no constitutional problem with Proposition 12. So when you look at the history, and I should note that we filed an amicus brief in the case on behalf of law professors focusing on this history, it's clear that the Commerce Clause was the framers' response to rampant economic protectionism by the states under the Articles of Confederation. The federal government at the time lacked the power to regulate commerce, and so each state adopted its own commercial policies that served its own interests. This quickly led to trade wars in which states targeted other states' products with discriminatory burdens, creating economic rivalries that escalated into political hostility. And so a key reason the framers adopted the Commerce Clause and the Constitution itself was to end this pattern of economic competition among the states that threatened to unravel the Union. So this history only supports a really narrow role for the courts under the Dormant Commerce Clause, a role limited to striking down protectionist and discriminatory state trade barriers, but otherwise giving the states wide leeway to legislate in ways that may affect interstate commerce. And I should note that longstanding Supreme Court precedent reflects exactly that understanding. So under this precedent, under this history, Proposition 12 should be fine. It's not protectionist. It's not discriminatory. There's simply no basis in the Constitution for the court to overturn the will of California's voters by striking Prop 12 down. So this case should be a slam dunk, but it's important to note that it comes to a court that has over the past decade become increasingly hostile to business regulation and increasingly eager to reshape the law in favor of corporate interests. And that's no less true when it comes to state regulation than federal regulation. Now, fortunately, based on the questions at oral argument, the justices seemed poised to reject the most extreme arguments that business interests made against Proposition 12. But a less sweeping ruling in industry's favor still appeared to be on the table. And to Joan's question about why we still haven't seen a decision in this case so many months after the argument, I think it's possible because the court is trying to figure out some kind of seemingly compromise position. But a compromise position, while it might initially look moderate, and importantly, might allow Proposition 12 to survive, could have big ramifications for the consideration of other state laws. And that's why this case is a big deal, not only for Californians, but for anyone who thinks that states should be able to pass environmental and health and safety laws designed to protect their own residents. So one possibility that seemed on the table at argument was that the justices might revive the case by sending it back to a lower court for an evaluation of whether Prop 12's costs outweigh its benefits. And again, Prop 12 would almost certainly survive in this scenario. But this decision would require the Supreme Court to backtrack, either implicitly or explicitly, on precedent that makes clear that laws that increase a company's compliance costs don't constitute a significant burden on interstate commerce. In other words, the Constitution does not protect any company's preferred business model. And so if the court were to backtrack on that, the result would be much more litigation in which judges are called upon to second guess the wisdom of choices made by voters and legislatures. And what's important to recognize is these kind of ostensibly moderate rulings are among the ways that today's court moves the law further and further toward privileging interests of big business. And so that's why this is really a case to be watching, not only for the ultimate outcome, but for how the court ends up getting there.
Thanks, Brianne. Actually, it's great to have more of an explanation of that one because it just hasn't gotten as much attention as the others. And David, if you would pick up now on 303 Creative versus Elena's, which essentially brings us back to Masterpiece Cake Shop, where they punted back a few years ago in the opinion by Justice Kennedy. And I'd be curious if you think they're really ready to go much further this time, both for speech and for implications for religious rights too.
Right. So this time around, they only took up the speech question. They declined to take up the religious freedom question. So the question, as the court put it, is, can an artist be compelled to create a wedding website for a gay couple when she opposes the message that the website would present? I think, more accurate statement of the question is, can a business or can an artist who chooses to go into business to serve the public discriminate against customers based on their sexual orientation? The thing about public accommodations laws is that they don't require anyone to go into business to serve the public. Most artists, most writers or freelancers, they don't serve the public generally. They, write what they want, they paint what they want, and then they're not regulated by public accommodations laws. So You don't have to go into business to serve the public in the first place. If you choose to go into business to serve the public, you're bound by these laws. But these laws don't regulate what you create. So you can, choose to open a business, for example, that sells only Christmas related merchandise. And that's not a violation of the public accommodations laws. You don't have to sell Hanukkah related merchandise as well. But you can't put a sign up on your store that says, Jews not welcome here. We don't serve Jews or Muslims. So how is the case likely to come out? It's an abstract case because it's a pre-enforcement challenge. The website designer has actually never made a website for any wedding, straight or gay. And so it's being litigated on the basis of fairly abstract stipulations. But I think, if the court views it as she would deny the same website to a gay couple that she would sell to a straight couple, saying, website saying, here's where our wedding's going to be, here are some places to stay, and here's our registry. If she would provide that to one but not to the other, then she's discriminating on the basis of identity, and she's violated the Colorado law. And the fact that she's engaged in an expressive service doesn't give her the right to do that. The New York Times is an expressive service, but it can't refuse to sell subscriptions to gay couples or to Black customers. On the other hand, if the court views this as a case in which she just doesn't want to make a same-sex wedding website, a website that celebrates same-sex weddings, and she wouldn't make that website for anybody, then it's like the Christmas store. She's just choosing what she wants to sell, and she's not selling it to some. She won't sell same-sex wedding websites to anybody. If they treat the case as that, then I think they're likely to find that it is protected by the First Amendment. You have a First Amendment right to choose what you sell. And if indeed she would not sell this to anybody, then she's not engaging in discrimination. That result, which I think is probably the most likely result, if it's written narrowly like that, would not open up a First Amendment license to discriminate. The broader argument, the argument that Alliance Defending Freedom is making, the argument that they made in Masterpiece Cake Shop and that the court was not willing to accept at that point, was if you're engaged in an expressive business, you cannot be required to treat all customers equally. That would be a disaster and would be a radical departure from the court's many precedents over the years that have held that no, public accommodations laws apply to all businesses, and you can't discriminate against someone based on who they are simply because you have a particular religious or political point of view.
Thanks, David. And again, if people have questions, put them in the queue because we'll have a nice chunk of time at the end to try to get to some audience questions. And then finally, our last section on the Constitution and economic justice. Easha is going to take another case that's a little bit like the pork producers one, hasn't gotten as much attention, but it's really important. Glacier Northwest versus International Brotherhood of Teamsters, involving the cement truck drivers who went on strike. And then after that, we'll go to Brianne with the student loan forgiveness cases.
Thanks so much. And thanks to the Constitutional Accountability Center for having me today. So in the case I'm going to talk about, the Stanford Law School Supreme Court Clinic represented the union, the respondent in the case. As Joan said, they'd organized concrete truck drivers to strike for better wages and working conditions. Drivers go on strike, no drivers to deliver the concrete, some of the concrete hardens. That's sort of the usual story of a strike. What's strange here is the employer then turns around and sues the union in state court for the value of that hardened concrete. And the state court does what state courts have been doing for 2 generations now, which is applying the Supreme Court precedent from the 1950s called Garmin to say, no, the right to strike is federally protected. You cannot turn to state courts to try to gouge the union for exercising that right. Again, sort of a run-of-the-mill application of precedent, but the Supreme Court then grants certiorari. Now, to sort of lay out the stakes here, the Garmin rule that I'm describing is a critical part of the right to strike. Getting rid of Garmin, allowing state court litigation over the value of a product that's damaged when workers go on strike, that functionally guts the right to strike, right? Imagine farm worker strikes and then the employer can sue that farm worker for the value of the crops that rot in the field because there's no one to pick the crops. Or grocery store employee strikes and grocer can turn around and sue the employee for the value of milk that spoils because the workers have left and there's no one to shelve it, and so on, right? If unions can be sued for the value of a product that gets spoiled, it's impossible to strike. Or at the very least, it's impossible to strike at a time that would actually impact the employer. So here's the problem. This Garmin opinion I've been talking about says it's basing its holding not on, the text of the statute, but on, quote, statutory penumbras and, quote, Delphic inferences of congressional intent. And of course, the idea that you would craft a rule from penumbras and Delphic inferences, that's anathema to this current court. So much of our work in this case had to do with explaining that the opinion is actually very much tethered to the text and structure of the statute. We had argument in January, and I want to highlight two themes, one related to labor law and one kind of broader. So the theme related to labor law, the court actually hasn't had a right to strike case in more than a generation, and it kind of shows. So even the liberal justices don't seem to kind of grasp the stakes of this case in the way they do in other economic justice cases. So even the liberal justices signaled this sort of openness to a rule that distinguishes between, quote, an ordinary strike and one that intends to destroy the employer's property, which sounds good, right? But in actuality, the line between I intend to strike at a moment that would be inconvenient for my employer, such that they're either forced to come to the bargaining table or expend resources on hiring someone else to do this work. And if they don't, it will lose property because that's how I use the strike to gain leverage. The line between that and I intend to strike when the employer will lose property, that's a razor thin line. And expecting unions to fight over that line on pain of being liable for all of the property that might get destroyed if the employer does not hire alternative workers, that will have a substantial chilling effect on the right to strike. So that's the kind of labor law theme. The broader theme is this. Petitioner made a move that I think we've seen a few times kind of this term alone. They don't say overrule Garmin, but they say Garmin's been on shaky foundation for decades now. You don't need to overrule it, but at least you should interpret it narrowly. We saw something similar with last month's confrontation clause argument, SAMIA, where the United States government seems to say, don't overrule Bruton, which is kind of a Warren Court precedent about when you can introduce a co-defendant's confession. Don't overrule it, but just recognize you might not reach the same outcome today, so interpret it narrowly. And I think this is sort of a savvy move that we'll see more of, both because the current court has such a majority committed to these particular methodologies, textualism and originalism, but because this court has a kind of unique willingness not only to overrule precedent outright, but also to cabin precedent to kind of tick it's good for one right only, right? So think about Bivens, the case that says you can imply a right of action against the federal government, where the court has basically said, come to us with the facts of Bivens itself, or you're out of luck. Think about Justice Kavanaugh's concurrence in Vega, where he says, I think Miranda was probably wrong, so I'm going to just vote against any party that has to rely on Miranda, even though I'm not going to overrule it. I could go on and on, right? There's many examples. But the bottom line is that this move, not let's overrule, so we'll see a lot of that, but let's read this case so narrowly it functionally doesn't apply anymore, is going to come up again and again. And seeing how the court reacts to those arguments is going to be where a lot of the action is on some of our issues going forward.
Thanks, Easha. Brianne is going to take the student loan forgiveness cases. And one question I would have is, I'm sure you're going to touch on the major questions issue. And, I've always been curious about how much they present that as a way to, rein in the agencies. But in so many ways, it further empowers judges and really ultimately the Supreme Court.
I think that's exactly right. This is an important economic justice case, but I was actually going to say, even though a lot of people talk about this as a case about executive power, I think it is really a case about congressional power and whether the courts will respect congressional policy judgments or instead try to displace those judgments with their own determinations. And I say that because here we have a very clear statute, a statute passed by Congress, signed by the president, that gives the education secretary broad power to respond to a national emergency by waiving or modifying any statutory or regulatory provision governing the student loan programs. The whole idea is to ensure that borrowers, student loan borrowers, are not worse off financially because of a national emergency. And I should note here that we filed an amicus brief on behalf of Representative George Miller, who is one of the co-sponsors of that legislation. And so the question before the court is whether that broad language is sufficient to authorize the Biden administration's student debt relief plan, or instead whether Congress needed to be even clearer, even more specific, because there are significant economic stakes here. And of course, I should note that before the court even gets to that merits question, it also has to determine whether it even has the authority to decide this case at all. There are real questions about standing in these cases. One of these cases brought by 6 states with Republican attorneys general, and one brought by 2 individual student loan borrowers. And if the court applies its traditional standing rules, which require a plaintiff with injury, a plaintiff whose injury can be redressed by a court order, there's real reason to think the court should not even reach the merits of the cases at all. But let's assume that the court does, and the court reaches the question of whether there is legal authority for the Biden administration student debt relief plan. What should it do? And what I think it should do is engage in the straightforward analysis of the text of the statute and conclude, given that broad text, that the plan is authorized. And even Justice Kavanaugh at argument pointed out that the statute uses the word waiver, which, as he said, is an extremely broad word. And so the student debt relief plan is authorized by this broad language because the regulations requiring student borrowers to pay the full balance of their educational debts are provisions that can be waived or modified under this law in the case of a national emergency. And of course, we have been under a presidentially declared emergency since March of 2020. But the states that are challenging the debt relief plan don't want the court to just look at the plain language of the statute. Instead, they want the court to use the major questions doctrine, which you referenced, Joan. They want the court to use that doctrine to strike down the student debt relief plan. And this is a doctrine that conservative opponents of regulatory action are currently trying to use to strike down all sorts of different federal government policies across a wide range of issue areas. And that's why this case is really significant, not only because of the huge stakes of the student debt relief plan, but because of this major questions doctrine and how the court is going to continue to interpret it. At oral argument, the Solicitor General, Elizabeth Prelager, pushed back on the idea that the doctrine applies here. She argued this case is different from other cases in which the court has applied the doctrine because, as she put it, the Department of Education isn't claiming extravagant regulatory authority it doesn't have. And I think that's exactly right. In West Virginia, the case from last year where the court articulated the most recent version of the doctrine, it said that the court should apply this doctrine only in extraordinary cases. Extraordinary cases, that's the court's language. And it made clear that economic and political significance alone is not sufficient to trigger the doctrine. Courts also have to examine the history and breadth of the authority the agency is asserting, determine whether it represents a transformative expansion of the agency's power unlikely to have been authorized by Congress. And doing that is required not only by the court's precedent, but is necessary to alleviate the doctrine's tensions with things like textualism and the original meaning of the Constitution and separation of powers. One other interesting thing about the argument in this case that I want to highlight really briefly is that a number of the conservative justices asked about the fairness of the student debt relief plans. The Chief Justice, for example, talked about a hypothetical in which there are 2 kids coming out of high school and one can't afford college and takes out a loan, and the other decides to set up a lawn care service and takes out a bank loan for that. And he questioned why it was fair for one person to get relief and not another. And I think Justice Kagan, who pretty pointedly responded to that question herself at argument, points out why this is really a case about congressional power. She noted that Congress passed a statute that dealt with loan repayment for colleges, and it didn't pass a statute that dealt with loan repayment for lawn businesses. And so Congress made a choice, she said. And that may have been the right choice or it may have been the wrong choice, but that's Congress's choice. So this case is significant, as I said, not just because of the huge stakes for student loan borrowers, but also because what the court does is going to tell us a lot about whether it takes seriously its own precedent on standing and on the major questions doctrine. And if the court decides this case and decides it on major questions doctrine grounds, that will, I think, as you indicated, Joan, represent a huge power grab by the court at the expense of both of the other branches.
Thanks, Brianne. We've got some questions coming in, but I do want to ask one question myself first for this last session that I'd love for all the panelists to jump in, those who care to. You know, we have had one major action so far, and that was when the justices agreed to stay the lower court orders in the Mifflin-Pristone case. And I'm just wondering how much we should make of that, how much you make of it in terms of what it might suggest when the controversy comes back. are we in any way seeing a more chastened court, or was it just the most logical outcome given how far Judge Kaczmarek and the Fifth Circuit were going? Feel free to jump in, anyone.
I think possibly we're seeing a more chastened court. Certainly, it was the right logical response to the case that was brought before the court. If you compare it to Dobbs, for example, in Dobbs, conservative ideas about how judges should act were 100% in line with their overturning of Roe versus Wade. Roe versus Wade was sort of the paradigm case of judicial activism, et cetera, and so their conservative legal principles coincided with their opposition to abortion, and they overruled a 50-year-old precedent and took away rights from half of this country in one fell swoop. In this case, their conservative legal principles were at odds with the anti-abortion result that's sought here, because the case is brought by people who don't have standing, and conservative judicial rules basically are very restrictive on standing. It's brought way after the statute of limitations, and again, that's something that conservatives are, want to ultimately support. And it seeks to overturn the decision of an agency based on information outside of the record that the agency rested upon, and to put judges' decisions about medical and issues over the decisions of experts that have been given the authority to make those decisions. So I'm not surprised that at the end of the day, the 7 of the justices on the court were willing to grant the stay. But there's no decision. They haven't explained their reasoning. It's only a stay. The case ultimately will come back to them, presumably, if the Fifth Circuit sticks with some version of what it decided the first time around. And so we'll learn next year. But I think it's a good sign. It would have been a disastrous sign if it had gone the other way. But I think it would have. It was, as I said, it would require them to abandon their conservative principles to achieve a particular result. And the fact that they didn't do that is a good thing.
Anybody else want to add to that? Tona? Brianne? Okay. One other question I just want to ask in terms of trends before we get to a few questions in the queue. Any observations about Justice Jackson or even Justice Barrett, who I consider still new enough to want to figure out exactly what direction she's going to go in relative to her conservative brethren? Any early observations about Justice Jackson that anyone wants to mention before we move to some more questions on the cases?
I want to note, Joan, that I think we've seen how powerful and important it is that our country's courts reflect the rich demographic diversity that really characterizes America, as well as the diversity of our legal profession. And I think Justice Jackson has really shown that. She's brought an incredibly important perspective to the court as the first Black woman to serve, but she also brings to bear her rich legal career, which is quite diverse and different from her colleagues. I mean, she served at all levels of the federal judiciary. She was and is the first former public defender appointed to the court, and she also brings to bear her experience as a member of the Sentencing Commission. So I think we've already seen how significantly her experiences contribute to her perspective on these cases, and certainly an oral argument when it comes to talking about the realities in which race continues to impact and shape the American experience, especially when we're thinking about the pervasive impact of systemic racism that exists to this day. And I think, just to give a quick example, I think that was really on display during the affirmative action arguments, where you had Chief Justice Roberts ask a question about how a Black student from a well-to-do neighborhood like Grosse Pointe, Michigan, had anything different to contribute to a student body that would be distinctive or different from a white classmate. That really revealed a lack of understanding of what it is to be a racially isolated Black person in an educational institution. And I think, by contrast, Justice Jackson really brought into stark relief an example of how the petitioner's arguments in the affirmative action cases would really present an equal protection problem, because you had the story and the contrast of the two applicants, where one wanted to highlight their family's 5 generations of having attended UNC, right, in their essay, and another would be prevented from highlighting their family's exclusion from that university based on their race. And so I think that's a really important part to think about when we think about Justice Jackson's contributions.
Does anybody else want to jump in about any alliances they're starting to see either with Justice Jackson or Justice Barrett?
So maybe I'll jump in, and this pales by comparison to some of the themes that Tona laid out in terms of her contributions to the dialogue on the court. But I do want to kind of note for listeners this kind of burgeoning partnership between Justice Jackson and Justice Gorsuch, where a few times that I can think of, the two of them have been kind of out on a limb, separate and apart from the other justices. So I'm thinking of oral argument earlier this week in Tyler versus Hennepin County, a case where a local government seizes the home of a woman who failed to pay her property taxes, and a case that was largely teed up as a takings clause case, but in which Justices Jackson and Gorsuch, and those two justices alone, were interested in hearing from advocates about the excessive fines clause of the Constitution, which we think of as applying in the criminal context, and sort of saying, like, how might this apply in this civil setting, property taxes, but sort of clearly punitive. And a few months ago, in a case called Bittner versus the United States, again, a sort of civil case, so it's about the Bank Secrecy Act, Justice Jackson is the only justice to join the portion of Justice Gorsuch's majority opinion applying the rule of lenity, again, a doctrine we usually reserve for criminal statutes, to this kind of civil penalty context. So I don't know precisely how to read these tea leaves, right? 2 data points don't a trend make. But I suppose it wouldn't surprise me if these two are the most deeply skeptical of government power, right? She, the former public defender, he, the kind of self-styled libertarian. And so they're the sort of only two willing to kind of transmute some of these protections we think of as purely criminal into some of these kind of civil contexts where we see the government having a lot of leverage over individuals.
Thanks. Let me just quickly get to some questions since we only have a few more minutes. Please expand on the potentially narrow 303 creative ruling where the quote product is excluded and not the client, and how that would impact public accommodation law and our overall landscape.
Yes, I think the easiest way to think about it is comparing Masterpiece Cake Shop to a very similar but significantly different case in the UK from a couple of years ago. So Masterpiece Cake Shop, the baker argued that because I'm making an expressive product, a cake, I can refuse to sell it to a gay couple, regardless of what it looks like, even if it looks exactly the same as a cake that I would make for an opposite sex couple. And the court, while it didn't resolve the case, it did say, a business's philosophical or religious objections do not permit a public accommodation to discriminate on the basis of the identity of the customer. Compare that to a case in the UK Supreme Court from a couple of years ago, where a gay couple goes into a bakery and says, we would like a cake that essentially says gay pride on it. And the baker says, I don't make cakes that say gay pride on it. I won't make that cake for anybody. And the case goes up to the UK Supreme Court, and the UK Supreme Court says, that's not discrimination. If in fact the person is genuine, that they won't make this particular cake for anybody, then they're not treating gay and straight customers differently. So it's like, if you're a t-shirt manufacturer and you make Black Lives Matter t-shirts, and someone comes in and says, hey, I want you to make me a Proud Boys t-shirt, it's not a violation of the public accommodations law to say, no, I only make Black Lives Matter t-shirts. I'm not going to make you a Proud Boys. I wouldn't sell a Proud Boys t-shirt to anybody. That's not discrimination. So the argument that ADF is advancing, which is if you're engaged in an expressive business, public accommodations laws don't apply to you, would be a huge hole in public accommodations laws. Whereas if the court interprets the facts here more narrowly and says this is actually a situation where a business chose to make one product and not another, and not to discriminate on the basis of the identity of the customers, I don't think that's actually accurate in terms of what she was seeking. But that's, they have sort of changed the facts essentially in order to reach a narrow result. And that would not have the same effect of blowing open public accommodations laws for all expressive businesses.
Thanks. And Brianne, we just got a question about whether the fact that they've done really nothing, not gotten any of the major ones done, could actually affect what they do in the remaining. If they'll start trimming their sails, kind of pulling back. Do you have any thoughts on that?
Well, I mean, they definitely do have more work to do in a shorter period of time than is normally the case, because they are definitely behind where they normally are in terms of releasing opinions. And, they're certainly going to get them all done. And my guess is they will get them all done by, around the 4th of July, which is what they always do. But I do think it means we could see shorter opinions, fewer concurrences, justices taking less time to write opinions that don't necessarily need to be written, just because of the volume of work that they're obviously going to need to do to get all these opinions out in the next couple of months.
Sure. I think we're just about at the end. Let me just make sure that we haven't left anything in. We're talking about divides on the left side of the court now. Actually, this is a good question. And the question is, what are your thoughts on Groff, especially where there was a divide on the left side of the legal establishment? I guess I'd also be interested in any observations any of you have quickly on how the new left will align, given that that's where we saw the change in with Justice Jackson joining, if she might steer a little bit more toward the Justice Kagan approach or Justice Sotomayor. Easha, do you want to jump in?
Yeah, so, I think that when you talk about the difference between Justice Kagan and Justice Sotomayor, I think part of what you're talking about here is this historical sense that, in the past, Justice Sotomayor has spoken more to the public and Justice Kagan has spoken more to her colleague. That's sort of the stereotype. Justice Kagan joins these majorities that wind up being narrower than you might have thought. And there's sort of some sense that behind the scenes, she brokered this narrow compromise. Justice Sotomayor writes the fiery dissent that speak to the public and kind of get the public outraged. I think what I'm seeing actually is that gap narrowing quite a bit. So I'm curious if other folks on this panel have different thoughts, but I feel like I'm seeing Justice Kagan writing and signing onto the kinds of dissents that 5 or 10 years ago, she wasn't signing onto. And I think, frankly, that's a function of a world in which you not only have to pick off, the Chief Justice is now part of the liberal wing of the court, Joan, right? He's one of the foremost liberal justices on the court. You not only have to pick off the chief, you have to find at least one other person to join your side. There's not as much room left for the kind of maneuvering we associate with Justice Kagan. And so instead, I think you're seeing all 3 of the liberal justices doing a lot more speaking to the general public during oral argument, in their dissents, a skill that Justice Sotomayor has honed for quite some time, but I think is the move that has left liberal justices.
Anyone else on splits on the left? Since we'll have, or on the right to close us out? We've just got 2 more minutes here. Tona, thoughts about whether we'll see a more united front on the left side, as Easha was talking about, with Justice Kagan. Justice Kagan no longer has her partner in Justice Breyer to move toward the center.
I mean, I completely agree with what Easha flagged, right? I think we're seeing more speaking directly to the public, especially when the stakes are so high, right, in these cases. And we're seeing such disappointing and wild swings and sort of steps away from precedent. And so I completely agree with Isha's assessment there.
Elizabeth is about to come on in like half a minute. Anybody else have any concluding thoughts for our audience? Any predictions? Okay, thank you so much. Here we are, just 1 minute over. And thanks especially to CAC for the time and for setting up these panels.
Thank you so much to that panel that we just had that discussion with. It was so fabulous. Thank you, Joan, for keeping us moving and flowing through all of these really important topics. Thanks to everyone for tuning in. You can find out more about CAC on our website, theusconstitution.org, and follow us on Twitter @myconstitution. Thanks again.